This image shows 23 white men and one black man in suits sitting around a large boardroom-style table. Figure 6 150 years ago, corporate and regulatory boardrooms were almost exclusively male and white, as this meeting of the Federal Open Market Committee, an executive committee of the Federal Reserve banking system, demonstrates. How much has this changed today? Credit: Modification of FOMC Meeting 1970s by Harris and Ewing / Wikimedia Commons, public domain. Chapter outline. 6. 1. The workplace environment and working conditions. 6.2. What constitutes a fair wage. 6.3. An organized workforce. 6.4. Privacy in the workplace. The 2020 Gender Diversity Index shows that many Fortune 1000 boards of directors still lack diversity. 1. Women and minorities continue to be underrepresented at the Chief Executive Officer, CEO, level 2. 2. Does this sameness merely look bad, or are there ethical and business reasons why top U.S. management should be more diverse? Figure 6.1. A demographic disconnect between leadership and workforce influences working conditions in many ways. For example, if more women held leadership roles, would workplace sexual harassment have come to light before the Me Too movement? Would more companies offer paid family leave? If minorities were better represented at the executive level, would corporate lobbyists advocate differently for immigration and health care policies? When 70% of boardroom seats are occupied by white men, who make up only 30% of the population, many people's views, ideas, and opinions will go unheard in decisions that affect their lives and livelihoods. We have seen progress, but much remains to be accomplished. Does management have an ethical duty to try to diversify top leadership? Whatever individual responses we might offer to each of these questions, a significant theme in this chapter is that ethical behavior in the workplace is most effectively instituted when it is modeled by senior leadership. Learning objectives. By the end of this section, you will be able to identify specific ethical duties managers owe employees. Describe the provisions of the Occupational Safety and Health Act. Identify Equal Employment Opportunity Commission protections, including those against sexual harassment at work. Describe how employees' expectations of work have changed. All employees want and deserve a workplace that is physically and emotionally safe, where they can focus on their job responsibilities and obtain some fulfillment, rather than worrying about dangerous conditions, harassment, or discrimination. Workers also expect fair pay and respect for their privacy. This section will explore the ethical and legal duties of employers to provide a workplace in which employees want to work. Ethical decision-making and leadership in the workplace. A contemporary corporation always owes an ethical, and in some cases legal, duty to employees to be a responsible employer. In a business context, the definition of this responsibility includes providing a safe workplace, compensating workers fairly, and treating them with a sense of dignity and equality while respecting at least a minimum of their privacy. Managers should be ethical leaders who serve as role models and mentors for all employees. A manager's job, perhaps the most important one, is to give people a reason to come back to work tomorrow. Good managers model ethical behavior. If a corporation expects its employees to act ethically, that behavior must start at the top, where managers hold themselves to a high standard of conduct and can rightly say, "Follow my lead, do as I do." At a minimum, leaders model ethical behavior by not violating the law or company policy. One who says, "Get this deal done, I don't care what it takes," may very well be sending a message that unethical tactics and violating the spirit, if not the letter, of the law are acceptable. A manager who abuses company property by taking home office supplies or using the company's computers for personal business, but then disciplines any employee who does the same, is not modeling ethical behavior. Likewise, a manager who consistently leaves early but expects all other employees to stay until the last minute is not demonstrating fairness. Another responsibility business owes the workforce is transparency. This duty begins during the hiring process, when the company communicates to potential employees exactly what is expected of them. Once hired, employees should receive training on the company rules and expectations. Management should explain how an employee's work contributes to the achievement of company-wide goals. In other words, a company owes it to its employees to keep them in the loop about significant matters that affect them and their job, whether good or bad, formal or informal. A more complete understanding of all relevant information usually results in a better working relationship. That said, some occasions do arise when full transparency may not be warranted. If a company is in the midst of confidential negotiations to acquire, or be acquired by, another firm, this information must be kept secret until a deal has been completed or abandoned. Regulatory statutes and criminal law may require this. Similarly, any internal personnel performance issues or employee criminal investigations should normally be kept confidential within the ranks of management. Transparency can be especially important to workers in circumstances that involve major changes, such as layoffs, reductions in the workforce, plant closings, and other consequential events. These kinds of events typically have a psychological and financial impact on the entire workforce. However, some businesses fail to show leadership at the most crucial times. A leader who is honest and open with the employees should be able to say, "This is a very difficult decision, but one that I made and will stand behind and accept responsibility for it." To workers, euphemisms such as right-sizing to describe layoffs and job loss only sounds like corporate doublespeak designed to help managers justify, and thereby feel better and minimize guilt about their or the company's decisions. An ethical company will give workers advance notice, a severance package, and assistance with the employment search without being forced to do so by law. Proactive rather than reactive behavior is the ethical and just thing to do. Historically, however, a significant number of companies and managers failed to demonstrate ethical leadership in downsizing, eventually leading Congress to take action. The Worker Adjustment and Retraining Notification, WARN, Act of 1989 has now been in effect for almost 3 decades, protecting workers and their families, as well as their communities, by mandating that employers provide 60 days, advance notice of mass layoffs and plant closings, Figure 6. 2. This law was enacted precisely because companies were not behaving ethically. This figure shows 4 boxes total, with 2 on the left and 2 on the right. The boxes on the left each have an arrow that points toward the corresponding box on the right. The first box on the left says, "Notice required 60 days," and its corresponding box on the right has 2 bullets that say 100 or more total employees and 50 or more employees laid off. The second box on the left says exceptions, and its corresponding box on the right has 2 bullets that say does not include part-time workers, less than 20 hours, and does not include new workers, less than 6 months. Figure 6.2. The WARN law mandates advance notice of mass layoffs to workers so that they can adequately prepare for such an event. Attribution. Copyright Rice University, OpenStax, under CC by 4. 0 license. A report by the Cornell University Institute of Labor Relations indicated that, prior to passage of WARN, only 20% of displaced workers received written advance notice, and those who did received very short notice, usually a few days. Only 7% had 2 months' notice of their impending displacement. 4 employers typically preferred to get as many days of work as possible from their workforces before a mass layoff or closing, figuring that workers might reduce productivity or look for other jobs sooner if the company were transparent and open about its situation. In other words, when companies put their own interests and needs ahead of the workforce, we can hardly call that ethical leadership. Other management actions covered by WARN include outsourcing, automation, and artificial intelligence in the workplace. Arguably, a company has an ethical duty to notify workers who might be adversely affected, even if the WARN law does not apply, demonstrating that the appropriate ethical standard for management often exceeds the minimum requirements of the law. Put another way, the law sometimes is often slow to keep up with ethical reflection on best management practices. Workplace safety under the Occupational Safety and Health Act. The primary federal law ensuring physical safety on the job is the Occupational Safety and Health Act OSHA, which was passed in 1970. 5. The goal of the law is to ensure that employers provide a workplace environment free of risk to employees' safety and health, such as mechanical or electrical dangers, toxic chemicals, severe heat or cold, unsanitary conditions, and dangerous equipment. OSHA also refers to the Occupational Safety and Health Administration, which operates as a division of the Department of Labor and oversees enforcement of the law. This act created the National Institute for Occupational Safety and Health, NIOSH, which serves as the research institute for OSHA and enunciates appropriate standards for safety and health on the job. Employer obligations under OSHA include the duty to provide a safe workplace free of serious hazards, to identify and eliminate health and safety hazards, Figure 6. 3. To inform employees of hazards present on the job and institute training protocols sufficient to address them, to extend to employees protective gear and appropriate safeguards at no cost to them, and to publicly post and maintain records of worker injuries and OSHA citations. This image shows a teenage boy who is missing an arm. Figure 6.3. Harry McShane, who celebrated his 16th birthday a month or so before this photo was taken by social reformer and photographer Louis Wicks Hine, lost his left arm as a result of a workplace injury in May 1908 in Cincinnati, Ohio. McShane had already been working in the factory for more than 2 years. Before federal safety regulations, such as OSHA and FLSA, catastrophic injuries on the job were common, as was the presence of children in the workforce. McShane received no compensation for his injuries. Credit: modification of Louis Wicks Hine's Harry McShane 1908 by Fordmatics Fraud/Wikimedia Commons, public domain. OSHA and related regulations give employees several important rights, including the right to make a confidential complaint with OSHA that might result in an inspection of the workplace, to obtain information about the hazards of the workplace and ways to avoid harm, to obtain and review documentation of work-related illnesses and injuries at the job site, to obtain copies of tests done to measure workplace hazards, and protection against any employer sanctions as a consequence of complaining to OSHA about workplace conditions or hazards. 6. A worker who believes his or her OSHA rights are being violated can make an anonymous report. OSHA will then establish whether there are reasonable grounds for believing a violation exists. If so, OSHA will conduct an inspection of the workplace and report any findings to the employer and employee, or their representatives, including any steps needed to correct safety and health issues. OSHA has the authority to levy significant fines against companies that commit serious violations. The largest imposed to date were against BP, the oil company responsible for the largest oil spill in U.S. history, discussed in the feature box on BP Deepwater Horizon oil spill and government regulation. OSHA took into account that 17 workers died on BP's rig Deepwater Horizon as a result of the initial explosion and fire in April 2010. Consequently, rig worker safety was upgraded by statute. Total OSHA penalties issued to BP from 2005 to 2009 exceed $102 million. 7. Other large fines issued over the last 30 years include $2.8 million against Union Carbide for violations related to an explosion and fire at its plant in Seadrift, Texas, in March 1991, $2 million levied against Samsung Guam in the wake of numerous worksite accidents at Guam's International Airport in 1995, and $7 million against Imperial Sugar in connection with an explosion at the company's plant in Port Wentworth, Georgia, in February 2008. More recently, OSHA fined the producers of The Walking Dead $12,675, the maximum allowable for a single citation, in the wake of the death of a stuntman working on an episode of the television show in Georgia in July 2017. These fines demonstrate that the agency is serious about trying to protect the environment and workers. However, for some, the question remains whether it is more profitable for a business to gamble on cutting corners on safety and pay the fine if caught than to spend the money ahead of time to make workplaces completely safe. OSHA fines do not really tell the whole story of the penalties for workplace safety issues. There can also be significant civil liability exposure and public relations damage, as well as worker compensation payments and adverse media coverage, making an unsafe workplace a very expensive risk on multiple levels. Link to learning. Read this OSHA fact sheet about fines and penalties to learn more. A workplace free of harassment. Employers have an ethical and a legal duty to provide a workplace free of harassment of all types. This includes harassment based on sex, race, religion, national origin, and any other protected status, including disability. Employees should not be expected to work in an atmosphere where they feel harassed, prejudiced against, or disadvantaged. The two complaints most frequently filed with the Equal Employment Opportunity Commission, EEOC, which strives to eliminate racial, gender, and religious discrimination in the workplace, are sexual harassment and racial harassment. Together, these categories made up 2/3 of all cases filed during 2017. More than 30,000 complaints of sexual, gender, racial, or creedal harassment are filed each year, illustrating the frequency of the problem. 10. The EEOC enforces Title VII of the Civil Rights Act, CRA, of 1964, which prohibits workplace discrimination including sexual harassment. 11. As discussed elsewhere in the text, the CRA also protects employees from discrimination based on race, gender, religion, and national origin. According to EEOC guidelines, it is unlawful to sexually harass a person because of that person's sex, either through explicit offers in exchange for sexual favors, known as quid pro quo, or through actions at a broader, more systemic level that create a hostile working environment. Sexual harassment includes unwelcome touching, requests for sexual favors, any other verbal or physical harassment of a sexual nature, offensive remarks based on a person's sex, and off-color jokes. The harasser can be the victim's supervisor, which creates company liability the first time it happens, or a peer coworker, which usually creates liability after the second time it happens, assuming the company had notice of the first occurrence. It can even be someone who is not an employee, such as a client or customer, and the law applies to men and women. Thus, the victim and the harasser both can be either a woman or a man, and offenses include both opposite sex and same-sex harassment. Although the law does not prohibit mild teasing, offhand comments, or isolated incidents that are not serious, harassment does become illegal when, according to the law, it is so frequent that it creates a hostile or offensive work environment, or when it is so severe that it results in an adverse employment decision, such as the victim being fired or demoted. 12. It is management's responsibility to prevent harassment through education, training, and enforcement of a policy against it, and failure to do so will result in legal liability for the company. 2. Relatively recent examples of workplace environments that descended into the worst excesses of sexist and other inappropriate behavior occurred at American Apparel and Uber. In both cases, principal leaders were mostly men who engaged in ruthless, no-holds-barred management practices that benefited only those subordinates who most resembled the leaders themselves. Such environments may thrive for a while, but the long-term consequences can include criminal violations that produce hefty fines and imprisonment, bankruptcy, and radical upheaval in corporate management. At American Apparel and at Uber, these events resulted in the dismissal of each company's CEO, Dov Charney, who also was the founder of the company, and Travis Kalanick, who was one of the corporation's founders, respectively. 13. In 2017 and 2018, a renewed focus on sexual harassment in the workplace and other inappropriate sexual behaviors brought a stream of accusations against high-profile men in politics, entertainment, sports, and business. They included entertainment industry mogul Harvey Weinstein, Pixar's John Lasseter, on-air personalities Matt Lauer and Charlie Rose, politicians such as Roy Moore, John Conyers, and Al Franken, and Uber's Kalanick, to name just a few. Figure 6.4. Part A shows Matt Lauer. Part B shows Travis Kalanick. Figure 6.4. Major figures in the news and entertainment industries, as well as Silicon Valley, have been accused of sexual harassment and often terminated or forced into retirement. Examples include Matt Lauer of NBC A and Travis Kalanick at Uber B. Credit a modification of hires 90,402 and 696 M018B by Chad J. McNeely / Wikimedia Commons, public domain. Credit B. Modification of GES opening plenary on June 23, 2016 by GES Photo / Flickr, public domain. The workplace harassment problem has continued for many decades despite the EEOC's enforcement efforts. It remains to be seen whether new public scrutiny will prompt a permanent change in the workplace. The Ford Motor Company serves as a relevant example. Decades after Ford tried to address sexual harassment at 2 Chicago-area assembly plants, the abuse at the plants evidently continues. According to legal action filed with the EEOC in the early 1990s, conditions for women working at some Ford auto assembly plants were hostile. Female employees alleged they were groped, that men pressed against them and simulated sex acts, and that men even masturbated in front of them. They further asserted that men would routinely make crude comments about the figures of female coworkers, and graffiti depictions of penises were everywhere, carved into tables, spray painted onto floors, and scribbled on walls. Managers and floor supervisors were accused of giving women better assignments in return for sex and punishing those who refused. 14. In the 1990s, lawsuits and an EEOC action led to a $22 million settlement in which Ford admitted to widespread misconduct and committed to crack down on the offenders. However, it seems Ford still did not learn its lesson, or, after almost 3 decades, the memory dimmed and they slipped right back into old habits. In August 2017, the EEOC reached a new $10 million settlement with Ford for sexual and racial harassment at the 2 Chicago plants. Though Ford did not admit any wrongdoing in the recent settlement, it appears that neither millions of dollars in earlier damages nor promises by management led to any serious change. The New York Times interviewed some of the women at Ford 15 and Sharon Dunn, who was a party of the first case and is now again a party of the second, said, "For all the good that was supposed to come out of what happened to us, it seems like Ford did nothing. If I had that choice today, I wouldn't say a damn word." A satisfied workforce. Although the workplace should be free of harassment and intimidation of every sort, and management should provide a setting where all employees are treated with dignity and respect, ideally, employers should go much further. Most people spend at least 1/3 and possibly as much as 1/2 of their waking hours at work. Management, therefore, should make work a place where people can thrive, that fosters an atmosphere in which they can be engaged and productive. Workers are happier when they like where they work, and when they do not have to worry about childcare, health insurance, or being able to leave early on occasion to attend a child's school play, for example. For our grandparents' generation, a good job was dependably steady, and employees tended to stay with the same employer for years. There were not many extras other than a secure job, health insurance, and a pension plan. However, today's workers expect these traditional benefits and more. They may even be willing to set aside some salary demands in exchange for an environment featuring perquisites, or perks. Non-monetary benefits, such as a park-like campus, an on-the-premises gym or recreational center, flex-time schedules, on-site day care and dry cleaning, a gourmet coffee house or cafe, and more time off. This section will explore how savvy managers establish a harmonious, compassionate workplace while still setting expectations of top performance. Happy employees are more productive and more focused, which enhances their performance and leads to better customer treatment, fewer sick days, fewer on-the-job accidents, and less stress and burnout. They are more focused on their work, more creative and better team players, and they are more likely to help others and demonstrate more leadership qualities. How, then, does an employer go about the process of making workers happy? Research has identified several pitfalls that managers should avoid if they want to have a good working relationship with their direct reports, and indeed, all their employees. 16.1 is making employees feel like they are just employees. To be happy at work, employees instead need to feel like they know each other, have friends at work, are valued and belong. Another pitfall is remaining aloof or above your employees. Taking an authentic interest in who they are as people really does matter. When surveys ask employees, "Do you feel like your boss cares about you?" Too frequently the answer is no. One way to show caring and interest is to recognize when employees are making progress. Another might be to take a personal interest in their lives and families. Asking employees to share their ideas and implementing these ideas whenever possible is another form of acknowledgement and recognition. Pause and highlight important milestones people achieve, and ensure that they feel their contributions are noticed by saying thank you. Good advice to new managers includes making work fun. Allow people to joke around as appropriate so that, when mistakes occur, they can find humor in the situation and move forward without fixating simply on the downside. Celebrate accomplishments. Camaraderie and the right touch of humor can build a stronger workplace culture. Encourage exercise and sleep rather than long work hours, because those two factors improve employees' health, focus, attention, creativity, energy, and mood. In the long run, expecting or encouraging people to regularly work long hours because leaving on time looks bad is counterproductive to the goals of a firm. Accept that employees need to disengage sometimes. People who feel they are always working because their management team expects they must remain in touch via email or mobile phone can become tremendously stressed. To combat this, companies should not expect their workers to be available around the clock, and workers should not feel compelled to be so available. Rather, employers should allow employees to completely disengage regularly so they can focus on their friends and families and tend to their own personal priorities. By way of international comparison, according to a recent article in Fortune, Germany and France have actually gone as far as banning work-related emails from employers on the weekends, which is a step in the right direction, even if only because disconnecting from work is now mandated by law. 17. Employers must decide exactly how to spend the resources they have allocated to labor, and it can be challenging to make the right decision about what to provide workers. Figure 6.5. Should managers ask employees what they want? Benchmark the competition. Follow the founder's or the board's recommendations. How does a company make lifestyle benefits fair and act ethically when there is backlash against family-friendly policies from people who do not have their own families? Unlike the purchase of raw materials, utilities, and other budgetary items, which is driven primarily by cost and may present only a few choices. Management's offering of employee benefits can present dozens of options, with costs ranging from minimal to very high. Work-at-home programs may actually cost the company very little, for example, whereas health insurance benefits may cost significantly more. In many other industrialized countries, the government provides, i.e., subsidizes, benefits such as health insurance and retirement plans, so a company does not have to weigh the pros and cons, i.e., do a cost-benefit analysis of what to offer in this area. In the United States, employee benefits become part of a cost-benefit analysis, especially for small and mid-sized companies. Even larger companies today are debating what benefits to offer. This image shows a room with a shuffleboard table and a foosball table. Figure 6.5 workplace or clubhouse. Some companies offer playful perks in an effort to attract the best employees and increase worker satisfaction. Credit. Work by Jason Putch, Photography, Spark, Baltimore, CC by 40. Management has to decide not only how much money to spend on benefits and perks, but precisely what to spend the money on. Another decision is what benefit choices management should allow each employee to make, and which choices to make for the workforce as a whole. The best managers communicate regularly with their workforce. As a result, they are more likely to know and be able to inform top management about the types of perks most desired and most likely to attract and keep good workers. Figure 6.6 shows that men and women do not always want the same benefits, which presents a challenge for management. For instance, many women place about twice as much value as many men do on day care, 23%, 11%, and on paid family leave, 24%, 14%. Also valued more highly generally by women than by men are better health insurance, work-from-home options, and flexible hours, whereas more men value an on-site gym and free coffee more than women typically do. This chart is a bar chart that shows the percentage of men and women who rank the importance of different benefits as a trade-off to earnings. The benefits are listed on the left side, and the bars of the chart extend to the right. There is a bar for men and a bar for women for each benefit. The first benefit listed is better health, dental, and vision insurance, and 61% of women and 47% of men ranked it. Then work-from-home options was ranked by 55% of women and 40% of men. Then more flexible hours was ranked by 47% of women and 38% of men. Then unlimited vacation was ranked by 47% of women and 33% of men. Then paid maternity-paternity leave was ranked by 24% of women and 14% of men. Then student loan assistance was ranked by 24% of women and 20% of men. Then free daycare services was ranked by 23% of women and 11% of men. Then tuition assistance was ranked by 16% of women and 14% of men. Then free fitness yoga classes was ranked by 11% of women and 9% of men. Then free gym membership was ranked by 11% of women and 12% of men. Then free coffee was ranked by 10% of women and 12% of men. Then free snacks was ranked 9% of women and 10% of men. Then company-wide retreats was ranked by 6% of women and 7% of men. Then team bonding events was ranked by 5% of women and 7% of men. Then free weekly employee outings was ranked by 5% of women and 6% of men. Then on-site gym was ranked by 4% of women and 6% of men. Figure 6.6 as this chart shows, men and women view the importance of various benefits differently, even if their top-ranked benefits are the same, i.e., better insurance, work-from-home options, and more flexible hours. Attribution. Copyright Rice University, OpenStax, under CC by 40 license. Age and generation also play a role in the types of perks that employees value. Workers aged 18 to 35 rank career advancement opportunities, 32%, and work-life balance, 33%, as most important to them at work. However, 42% of workers older than 35 say work-life balance is the most important feature. This is likely because Generation X, born in the years 1965–1980, place a high value on opportunities for work-life balance. Although, like baby boomers, born in the years 1946–1964, they also value salary and a solid retirement plan. On the other hand, millennials born in the years 1980–1997 appreciate flexibility, having a choice of benefits, paid time off, the ability to telecommute, flexible hours, and opportunities for professional development. 18. The menu of benefits and perks thus depends on several variables, such as what the company can afford, whether employees value perks over the more direct benefit of higher pay, what the competition offers, what the industry norm is, and the company's geographic location. For example, Google is constantly searching for ways to improve the health, well-being, and morale of its Googlers. The company is famous for offering unusual perks, like bicycles and electric cars to get staff around its sprawling California campus. Additional benefits are generous paid parental leave for new parents, on-site childcare centers at one location, paid leaves of absence to pursue further education with tuition covered, and on-site physicians, nurses, and health care. Other perks are gaming centers, organic gardens, eco-friendly furnishings, a pets at work policy, meditation and mindfulness training, and travel insurance and emergency assistance on personal and work-related travel. On the death of a Google employee, his or her spouse or domestic partner is compensated with a check for 50% of the employee's salary each year for a decade. In addition, all a deceased employee's stock options vest immediately for the surviving spouse or domestic partner. Furthermore, a deceased employee's children receive $1,000 per month until they reach the age of 19, or until the age of 23 if they are full-time students. 19. Linked to learning, of course, Google is not the only company that offers good perks. Another is the software giant SAS. Glassdoor has an article describing some interesting benefits offered by other companies in 2017. Do a quick comparison of a few of these companies. Do the perks influence your choice? Would you be willing to work for any of them? In addition to offering benefits and perks, managers can foster a healthy workplace by applying good people skills as well. Managers who are respectful, open, transparent, and approachable can achieve two goals simultaneously: a workforce that is happier and also one that is more productive. Good management requires constant awareness that each team member is also an individual working to meet both personal and company goals. Effective managers act on this by regularly meeting with employees to recognize strengths, identify constructive ways to improve on weaknesses, and help workers realize collective and individual goals. Ethical businesses and good managers also invest in efforts like performance management and employee training and development. These commitments call for giving employees frequent and honest feedback about what they do well and where they need improvement, thereby enabling them to develop the skills they need, not only to succeed in the current job, but to move on to the next level. Fostering teamwork by treating people fairly and acknowledging their strengths is also an important responsibility of management. Ethical managers, therefore, demonstrate most, if not all, of the following qualities: cultural awareness, positive attitude, warmth and empathy, authenticity, emotional intelligence, patience, competence, accountability, respectful, and honesty. Learning objectives. By the end of this section, you will be able to explain why compensation is a controversial issue in the United States, discuss statistics about the gender pay gap, identify possible ways to achieve equal pay for equal work, discuss the ethics of some innovative compensation methods, the Center for Financial Services Innovation, CFSI, is a nonprofit, nonpartisan organization funded by many of the largest American companies to research issues affecting workers and their employers. Findings of CFSI studies indicate that employee financial stress permeates the workplaces of virtually all industries and professions. This stress eats away at morale and affects business profits. A recent CFSI report details data showing that 85% of Americans are anxious about their personal financial situation and admit that their anxiety interferes with work. Furthermore, this financial stress leads to productivity losses and increased absenteeism, healthcare claims, turnover, and costs affecting workers who cannot afford to retire. 20. The report also indicates that employees with high financial anxiety are twice as likely to take unnecessary sick time, which can be expensive for an employer. The CFSI report makes clear that ensuring workers are paid a fair wage is not only an ethical practice, it is also an effective way to achieve employees' highest and most productive level of performance, which is what every manager wants. In the process, it also makes workers more loyal to the company and less likely to jump ship at the first sign of a slightly better wage somewhere else. The concept of a fair wage has a greater significance than simply one worker's pay or one company's policy. It is an economic concept critical to the nation as a whole in an economic system like capitalism, in which individuals pay for most of what they need in life, rather than receiving government benefits funded by taxes. The ethical issues for the business community and for society at large are to identify democratic systems that can effectively eradicate the financial suffering of the poorest citizens, and to generate sufficient wages to support the economic sustainability of all workers in the United States. Put another way, has the real income of average American workers declined so much over the past few decades that it now threatens the productivity of the largest economy in the world? Economic data as an indicator of fair wages. The Pew Research Center indicates that over the 35 years between 1980 and 2014, the inflation-adjusted hourly wages of most middle-income American workers were nearly stagnant, rising just 6%, or an average of less than 0.2% per year. 21. The Pew Research Center defines middle-class adults as those living in households with disposable incomes ranging from 65% to 200% of the national median, which is approximately $60,000. The data collected by the Economic Policy Institute, a nonprofit, nonpartisan think tank, show the same stagnant trend. 22. Contrast this picture with the wages of high-income workers, which rose 41% over the same years. Many economists, political leaders, and even business leaders admit that increasing wage and wealth disparities are not a sustainable pattern if the U.S. economy is to succeed in the long term. 23. Wage growth for all workers must be fair, which in most cases means higher wages for low and middle-income workers. Figure 6.7 presents evidence of the growth of the income gap in the United States since the start of the Great Recession in 2007. This chart is a bar chart titled Median Household Worth Prior to and After the Great Recession. The label for the y-axis is median household net worth in dollars, and the values start at 0 and increase by 100,000 up to 900,000. The labels for the x-axis are lower income, middle income, and upper income. There are bar graphs for the years 2007, 2013, and 2016 for each income group listed on the x-axis. All of the lower income graphs are below 100,000. The one for 2007 reaches about 20,000, and the ones for 2013 and 2016 decrease slightly from that. The middle income graphs range from about 160,000 to 100,000. The one for 2007 is at about 160,000, then 2013 is at about 100,000, and then 2016 is at about 110,000. The upper income graphs range from about 660,000 to 810,000. The one for 2007 is at about 74,000. Then 2013 is at about 660,000. And then 2016 is at about 810,000. Figure 6-7 stagnant income has been the reality for lower and middle-income American adults, with income in 2016 actually lower than it was 10 years before. This has not been the case for upper-income adults. Attribution. Copyright Rice University, OpenStax, under CC by 40 license. No reasonable person, regardless of profession or political party, would dispute that employees are entitled to a fair or just wage. Rather, it is in the calculation of a fair wage that the debate begins. Economists, sociologists, psychologists, and politicians all have opinions about this, as have most workers. Some of the factors that feature in calculations are federal and state minimum wage standards, the cost of living, and the rate of inflation. Should a fair wage include enough money to raise a family too, if the wage earner is the sole or principal support of a family? Figure 6-8 shows the growth, or lack of growth, in the buying power of a minimum wage earner since 1940. Compare the 20-year period of 1949 through 1968 with the 50-year period from 1968 through 2017. The difference has created a sobering reality for many workers. In the nearly 6 decades since 1960, the inflation-adjusted real minimum wage actually declined by 23%. That means minimum wage workers did not even break even. The value of their wages declined over 50 years, meaning they have effectively worked half a century with no raise. In the following chart, nominal wage represents the actual amount of money a worker earns per hour. Real wage represents the nominal wage adjusted for inflation. We consider real wages because nominal wages do not take into account changes in prices and therefore do not measure workers' actual purchasing power. This graph is titled Nominal versus Real Minimum Wage. The y-axis shows dollars, starting at 0 and increasing by $2 increments. The x-axis shows years from 1940 to 2010, increasing by 10-year increments. The trend line for nominal minimum wage starts at about $5, $70 in 1940, and fluctuates between this and about $4, until it spikes in 1950 to $8. There is a slight decrease, then it jumps again around 1955 to about $9. It goes back toward $8. In 1960, then steadily increases until another jump around 1968 to about $11.50. It decreases over the next few years back to about $9, $0, then goes back up to around $10, until about 1980. Then a steady decrease to about $7. Occurs from about 1980 to 1988. Around 1990, it goes back up to about $8, $0, then fluctuates between about $8, $0, and $7.50 until about 2000. There is a decline to about $6 until 2005, and then it increased back to just above $8 around 2010 before declining around. The trend line for real minimum wage is an increasing trend line. It starts at close to $0 in 1940 and steadily increases, with one period of no change around 1950 to 1965, to close to $2 around 1968. From about 1968 to 1973, there is no change. Then it steadily increases again until there is a large jump from about 1976 to 1980, when it reaches close to $4. Most of the time from 1980 to 1990 shows no change. Then it increases again from about 1989 to 1996, reaching about $5, $50. There is no change until about 2006 when it increases to $7.25 around 2008. Then it shows no change from there. Figure 6. 8. The graph contrasts the U.S. nominal wage dollar amount and the real wage dollar amount's purchasing power over the last 75 years, indicating a steady decline in purchasing power experienced by most workers. Attribution. Copyright Rice University, OpenStax, under CC by 40 license. One positive development for minimum wage workers is that state governments have taken the lead in what was once viewed primarily as a federal issue. Today, most states have a higher minimum hourly wage than the federal minimum of $7.25. States with the highest minimum hourly wages are Washington, $11.50, California and Massachusetts, $11, $0, Arizona and Vermont, $10, $50, New York and Colorado, $10, $40, and Connecticut, $10, $0. Some cities have even higher minimum hourly wages than under state law. For example, San Francisco and Seattle are at $15. As of the end of 2017, 29 states had higher minimum hourly wages than the federal rate, according to Bankrate.com. Figure 6.9. A map of the United States is titled Minimum Wage by State 2017. The states are colored in to show minimum wage. States with a minimum wage between $7.25 and $7.99 are Idaho, Utah, Wyoming, New Mexico, Texas, Oklahoma, Kansas, North Dakota, Iowa, Wisconsin, Missouri, Louisiana, Mississippi, Alabama, Tennessee, Kentucky, Indiana, New Hampshire, Pennsylvania, Virginia, North Carolina, South Carolina, and Georgia. States with a minimum wage between $8, $0 and $8. $74 are Nevada, Montana, South Dakota, Illinois, Arkansas, Ohio, New Jersey, Delaware, and Florida. States with a minimum wage between $8, $75 and $9. $49 are Hawaii, Colorado, Nebraska, Michigan, West Virginia, Maine, and Maryland. States with a minimum wage between $9.50 and $10. $24 are Oregon, Alaska, Arizona, Minnesota, New York, Vermont, Connecticut, and Rhode Island. States with a minimum wage between $10, $25 and $11.50 are Washington, California, Massachusetts, and Washington, D.C. Figure 6.9. As of 2017, there is a patchwork quilt of state-level minimum wage laws. Attribution. Copyright Rice University, OpenStax, under CC by 40 license. Unfair wages. The gender pay gap. Even after all possible qualifiers have been added, it remains true that women earn less than men. Managers sometimes offer multiple excuses to justify pay inequities between women and men, such as, women take time off for having babies, or women have less experience. But these usually do not explain away the differences. The data show that a woman with the same education, experience, and skills, doing the same job as a man, is still likely to earn less, at all levels from bottom to top. According to a study by the Institute for Women's Policy Research, even women in top positions such as CEO, vice president, and general counsel often earn only about 80% of what men with the same job titles earn. 24 data from the EEOC over the 5 years from 2011 through 2015 for salaries of senior-level officials and managers, defined by the EEOC as those who set broad policy and are responsible for overseeing execution of those policies, show women in these roles earned an average of about $600 per year compared with their male counterparts, who earned more than $800 per year. 25. That $200,000 difference amounts to a wage gap of about 35% each year. The same is true in mid-level jobs as well. In a long-term study of compensation in the energy industry, researchers looked at the job of a land professional, who negotiates with property owners to lease land on which the oil companies then drill wells, and found evidence of women consistently getting paid less than men for doing the same job. Median salaries were compared for male and female land professionals with similar experience, 1 to 5 years, and educational background, bachelor's degree, and men earned $7,000 more per year than their female counterparts. 26. Doesn't the law require men and women to be paid the same? The answer is yes and no. Compensation discrimination has been illegal for more than 50 years under a U.S. law called the Equal Pay Act, passed in 1963. But the problem persists. Women earned about 60% of what men earned in 1960, and that value had risen to only 80% by 2016. Given these historic rates, women are not projected to reach pay equity until at least 2059, with projections based on recent trends predicting dates as late as 2119. 27. These are aggregate data. Thus, they include women and men with the same job, or similar jobs, or jobs considered to fall in the same general category. But the data do not compare the salary of a secretary to that of a CEO, which would be an unrealistic comparison. Equal pay under the law means equal pay for the same job, but not for the equivalent job. Those companies wishing to avoid strict compliance with the law may use several devices to justify unequal pay, including using slightly different job titles, slightly different lists of job duties, and other techniques that lead to different pay for different employees doing essentially the same job. Women have taken employers to court for decades, only to find their lawsuits unsuccessful because proving individual compensation discrimination is very difficult, especially given that multiple factors can come into play in compensation decisions. Sometimes class action lawsuits have been more successful, but even then plaintiffs often lose. Can anything be done to achieve equal pay? One step would be to pass a new law strengthening the rules on equal pay, but two recent attempts to pass the Paycheck Fairness Act, S. 84 H.R. 377, and the Fair Pay Act, S. 168 H.R. 438, narrowly failed. 28. These or similar bills, if ever enacted into law, would significantly reduce wage discrimination against those who work in similar job categories by establishing equal pay for equivalent work, rather than the current law which uses the term same job. The idea of pay equivalency is closely related to comparable worth, a concept that has been put into action on a limited basis over the years, but never on a large scale. Comparable worth holds that workers should be paid on the basis of the worth of their job to the organization. Equivalent work and comparable worth can be important next steps in the path to equal pay, but they are challenging to implement because they require rethinking the entire basis for pay decisions. Linked to learning. Though the federal government has not yet passed the Paycheck Fairness Act, some states have taken action on their own. The website for the National Conference of State Legislatures, section on state equal pay laws, provides a chart listing states that go beyond the current federal law to mandate equal pay for comparable or equivalent work. Look up your state in the chart. How does it compare with others in this regard? If a woman's starting salary for the first job of her career is less than that of a man, the initial difference, even if small, tends to cause a systemic, career-long problem in terms of pay equity. Researchers at Temple University and George Mason University found that if a new hire gets $5,000 more than another worker hired at the same time, the difference is significantly magnified over time. Assuming an average annual pay increase of 5%, an employee starting with a $55,000 salary will earn at least $600,000 more over a 40-year career than an employee who starts an equivalent job with a $50,000 salary. This significantly affects many personal decisions, including retirement, because, all other things equal, a lower-paid woman will have to work 3 years longer than a man to earn the same amount of money over the course of her career. 29. Ethics across time and cultures. European approaches to the gender pay Gap, the policies of other nations can offer some insight into how to address pay inequality. Iceland, for example, has consistently been at the top of the world rankings for workplace gender equality in the World Economic Forum survey. 30. A new Icelandic law went into effect on January 1, 2018, that makes it illegal to pay men more than women, gauged not by specific job category, but rather in all jobs collectively at any employer with 25 or more employees, a concept known as an aggregate salary data approach. 31. The burden of proof is on employers to show that men and women are paid equally, or they face a fine. The ultimate goal is to eliminate all pay inequities in Iceland by the year 2022. The United Kingdom has taken a first step toward addressing this issue by mandating pay transparency, which requires employers with 250 workers or more to publish details on the gaps in average pay between their male and female employees. 32. Policies not directly linked to salary can help as well. German children have a legal right to a place in kindergarten from the age of 3 years, which has allowed 1/3 of mothers who could not otherwise afford nursery school or kindergarten to join the workforce. 33. In the United Kingdom, the government offers up to 30 hours weekly of free care for 3- and 4-year-old children to help mothers get back in the workforce. Laws such as these allow women, who are often the primary caregivers in a household, to experience fewer interruptions in their careers, a factor often blamed for the wage gap in the United States. The World Economic Forum reports that about 65% of all Organization for Economic Cooperation and Development, OECD, countries have introduced new policies on pay equality, including requiring many employers to publish calculations every year showing the gender pay gap. 34. Steps such as the collection and reporting of aggregate salary data, or some form of early education or subsidized childcare, are positive steps toward eventually achieving the goal of wage equality. Critical thinking: which of these policies do you think would be the most likely to be implemented in the United States and why? How would each of the normative theories of ethical behavior, virtue ethics, utilitarianism, deontology, and justice theory, view this issue and these proposed solutions? Part of the reason that initial pay disparity is heightened over a career is that when a worker changes jobs, the new employer usually asks what the employee was making in his or her last job and uses that as a baseline for pay in the new job. To combat the problem of history-based pay, which often hurts women, 8 states and numerous municipalities in the United States now ban employers from asking job applicants to name their last salary. 35. Although this restriction will not solve the entire problem, it could have a positive effect if it spreads nationally. In a survey by the executive search firm Korn Ferry, 46 of 100 companies said they usually comply with the legal requirements in force in the strictest of the locations in which they operate, meaning workers in states without this law might not be asked about their salary history during new job negotiations either. 36. Experiments in compensation: whether we are discussing fair wages, minimum wages, or equal wages, the essence of the debate often boils down to ethics. What should people get paid? Who should determine that? And should managers and upper management do only what is required by law or go above and beyond if that means doing what they think is right? Organizational pay structures are set by a variety of methods, including internal policies, the advice of outside compensation consultants, and external data, such as market salaries. An innovative compensation decision in Seattle may provide some insight. In 2011, a young man earning $35,000 a year told his boss at Gravity Payments, a credit card payments business, that his earnings were not sufficient for a decent life in expensive Seattle. The boss, Dan Price, who co-founded the company in 2004, claimed to be surprised and insisted that he had always emphasized the best pay for his employees. Nevertheless, he decided his employee was right. For the next 3 years, Gravity gave every employee a 20% annual raise. Still, profit continued to outgrow wages. So Price announced that over the next 3 years, Gravity would phase in a minimum salary of $70,000 for all employees. He reduced his own salary from $1 million to $70,000 to demonstrate the point and help fund it. The following week, 5,000 people applied for jobs at Gravity, including a Yahoo executive who took a pay cut to transfer to a company she considered fun and meaningful to work for. Price's decision started a national debate. How much should people be paid? Since 2000, U.S. productivity has increased 22%, yet inflation-adjusted median wages have increased only 2%. That means a larger share of capitalism's rewards are going to shareholders and top executives, who already earn an average of 300 times more than typical workers, up from 70 times more just a decade ago, and a smaller share is going to workers. If Gravity profits while sharing the benefits of capitalism more broadly, Price's actions will be seen as demonstrating that underpaying the workforce hurts employers. If it fails, it may look like proof that companies should not overpay. Price insisted that low starting salaries were antithetical to his values and felt that struggling employees would not be motivated to maintain the high quality that made his company successful with that compensation. He calls the $70,000 minimum wage an ethical and moral imperative rather than a business strategy. And though it will cost Gravity about $2 million per year, he has ruled out price increases and layoffs. More than half the initial cost was offset by his own pay cut, the rest by profit. Revenue continues to grow at Gravity, along with the customer base and the workforce. Currently, the firm has a retention rate of 91%. 37 Yet Price says managers' scorecards should measure purpose, impact, and service as much as profit. Price remains a controversial figure as a business leader, as his relationships with his ex-wife and other women have led to accusations of misogyny against him. It's up to the individual to conclude whether these accusations of personal misconduct, if true, impinge on or outweigh any credit he may be deserving for his progressive view on worker compensation. Michael Wheeler, a professor at Harvard Business School who teaches a course called Negotiation and the Moral Leader, recently discussed the aftermath of Dan Price's decision at Gravity. He interviewed other entrepreneurs about their plans for creative compensation to help develop a happy and motivated workforce. And it appears that some other companies are taking notice of how successful Gravity has been since Price made the decision to pay his workers more. 38 One of these entrepreneurs was Megan Driscoll, the CEO of PharmaLogix Recruiting, who, after hearing Dan Price speak to a group of executives, was inspired to raise the starting base pay of her employees by 33%. When Driscoll put her plan to work, her business had 46 employees and $6.7 million in revenue. A year later, staff and revenues had jumped to $72 and $15 million, respectively. Driscoll points to data showing her people are working harder and smarter after the pay raise than before. There has been a 32% increase in clients, and the client retention rate doubled to 80%. 39 Stefan Arstow, CEO of Tower Paddleboards, wanted to give his workers a raise, but his company did not have the cash. Instead, Arstow boldly cut the workday to 5 hours from the 10 hours most employees had been working. Essentially, that doubled their pay, and as a result, he says, employee focus and engagement have skyrocketed, as have company profits. 40 managers must carefully balance the short term, such as quarterly profits, versus long-term sustainability as a successful company. This requires recognizing the value of work that each person contributes and devising a fair, and sometimes creative, compensation plan. Learning objectives. By the end of this section, you will be able to discuss trends in U.S. labor union membership, Define codetermination. Compare labor union membership in the United States with that in other nations. Explain the relationship between labor productivity gains and the pay ratio in the United States. The issue of worker representation in the United States is a century-old debate, with economic, ethical, and political aspects. Are unions good for workers, good for companies, good for the nation? There is no single correct response. Your answer depends upon your perspective, whether you are a worker, a manager, an executive, a shareholder, or an economist. How might an ethical leader address the issue of the gap between labor's productivity gains and their relatively stagnant wages as compared with that of management? Organized labor. Americans' long-standing belief in individualism makes some managers wonder why employees would want or need to be represented by a labor union. The answer is, for the same reasons a CEO wants to be represented by an attorney when negotiating an employment contract, or that an entertainer wants to be represented by an agent. Unions act as the agent-lawyer negotiator for employees during collective bargaining, a negotiation process aimed at getting management's agreement to a fair employment contract for members of the union. Everyone wants to be successful in any important negotiation, and people often turn to professionals to help them in such a situation. However, in the United States, as elsewhere around the globe, the concept of worker organization has been about more than simply good representation. Unionization and worker rights have often been at the core of debates related to class economics, political power, and ethical values. There are legitimate points on each side of the union debate. Table 6.1. Pros and cons of unions. Pros of unions, cons of unions. Unions negotiate increased pay and benefits for workers. Unions can make it harder to fast-track promotions for high-performing workers and/or get rid of low-performing ones. Unions create a formal dispute resolution process for workers. Workers are required to pay union dues fees that some might rather not pay. Unions act as an organized lobbying group for worker rights. Unions sometimes lead to a closed culture that makes it harder to diversify the workforce. Collective bargaining agreements often set norms for employment for an entire industry, benefiting all workers, including those who are not at a union company. Collective bargaining contracts can drive up costs for employers and lead to an adversarial relationship between management and workers. Table 6.1. The value of unions is a topic that produces significant disagreement. Historically, unions have attained many improvements for workers in terms of wages and benefits, standardized employment practices, labor protections, e.g., child labor laws, workplace environment, and on-the-job safety. Nevertheless, sometimes unions have acted in their own interests to sustain their own existence, without primary concern for the workers they represent. The history of the worker movement, summarized in the video in the following link to learning, reveals that in the first half of the 20th century, wages were abysmally low, few workplace safety laws existed, and exploitive working conditions allowed businesses to use child labor. Unions stepped in and played an important role in leveling the playing field by representing the interests of the workers. Union membership grew to a relatively high level, 33% of wage and salary workers, in the 1950s, and unions became a force in politics. However, their dominance was relatively short-lived, not least because in the 1960s, the federal government started to enact employment laws that codified many of the worker protections unions had championed. In the 1980s and 1990s, the U.S. economy gradually evolved from manufacturing, where unions were strong, to services, where unions were not as prevalent. The service sector is more difficult to organize, due to a variety of factors such as the historical absence of unions in the sector, workers, widely differing work functions and schedules, challenging organizational status, and white-collar bias against unions. Link to learning. This 3-minute video entitled The Rise and Fall of U.S. Labor Unions, summarizes the history of the union movement. It is based on information from University of California, Santa Cruz professor William Domhoff and the University of Houston Bauer College of Business. These developments, along with the appearance of state right-to-work laws, have led to a decline in unions and their membership. Right-to-work laws give workers the option of not joining the union, even at companies where the majority has voted to be represented by a union, resulting in lower membership. Right-to-work laws attempt to counter the concept of a union shop or closed shop, which requires that all new hires automatically be enrolled in the labor union appropriate to their job function, and that union dues automatically be deducted from their pay. Some question the fairness of right-to-work laws, because they allow those who do not join the union to get the same pay and benefits as those who do join, and who pay unions dues for their representation. On the other hand, right-to-work laws provide workers the right of choice. Those who do not want to join a union are not forced to do so. Those who do not choose to join may end up having a strained relationship with union workers, however, when a union-mandated strike occurs. Some non-union members and even union members elect to cross the picket line and continue to work. Traditionally, these scabs, as they are derisively labeled by unions, have faced both overt and subtle retaliation at the hands of their coworkers, who prioritize loyalty to the union. 28 states have right-to-work laws, Figure 610. Notice that many right-to-work states, such as Michigan, Missouri, Indiana, Wisconsin, Kentucky, Tennessee, Alabama, and Mississippi, are among the top 10 states where automobiles are manufactured and unions once were strong. A map of the United States is titled, States with Right-to-Work Laws. The states with right-to-work laws are Nevada, Idaho, Utah, Arizona, Wyoming, North Dakota, South Dakota, Nebraska, Kansas, Oklahoma, Texas, Iowa, Missouri, Arkansas, Louisiana, Mississippi, Alabama, Tennessee, Kentucky, Indianapolis, Michigan, Wisconsin, West Virginia, North Carolina, South Carolina, Georgia, and Florida. The states without right-to-work laws are Alaska, Hawaii, Washington, Oregon, California, Montana, Colorado, New Mexico, Minnesota, Illinois, Ohio, Maine, Vermont, New Hampshire, Massachusetts, Connecticut, Rhode Island, New York, New Jersey, Pennsylvania, Maryland, Delaware, and Washington, D.C. Figure 6. 10 right-to-work states have typically been clustered in the South and Southeast, where unions have been traditionally less prevalent. Attribution. Copyright Rice University, OpenStax, under CC by 4. 0 license. According to the U.S. Bureau of Labor Statistics, total union membership in the United States dropped to 20% of the workforce in 1980. By 2016, it was down to about half that, Figure 611. 41 public sector government workers have a relatively high union membership rate of 35%, more than 5 times that of private sector workers, which is at an all-time low of 6.5%. White-collar workers in education and training, as well as first responders such as police and firefighters, now have some of the highest unionization rates, also 35%. Among states, New York continues to have the highest union membership rate at 23%, whereas South Carolina has the lowest, at slightly more than 1%. The graph is titled, Percentage of U.S. Workers who are union members, 1983 to 2017. The y-axis shows percentages from 10 to 25%, increasing by 5% increments. The x-axis shows years from 1980 to 2020, increasing by 10-year increments. The trend line starts at 20% and declines to just above 10% from 1983 to 2017. The decline from 1983 to about 1990 is more rapid and goes down to about 16%. The changes after that are more gradual, other than a decrease from about 16% to 14% from around 1994 to 1999. There is also a slight increase around 2006 to 2008 from about 12% to 12.5%. Figure 6, 11 union membership in the United States has steadily declined since 1980. Attribution: Copyright Rice University, OpenStax, under CC BY 40 license. Codetermination is a workplace concept that goes beyond unionization to embrace shared governance, in which management and workers cooperate in decision-making and workers have the right to participate on the board of directors of their company. Board-level representation by employees is widespread in European Union countries. Most codetermination laws apply to companies over a certain size. For example, in Germany, they apply to companies with more than 500 employees. 42. The labor union movement never has been quite as strong in the United States as in Europe. The trade union movement began in Europe and remains more vibrant there even today, and codetermination is thus not common in U.S. companies. Table 6.2. Unionization as percentage of workforce in 8 industrialized nations. Country workforce in unions, percent. Australia 25, Canada 30, France 9, Germany 26, Italy 35, Japan 22, Sweden 82, United Kingdom 29, United States 12. Table 6. 2. Labor union membership remains much higher in Europe and other group of 7 G7 countries than in the United States. Only France has a lower percentage of union membership. 43. Codetermination has worked relatively well in some countries. For example, in Germany, workers, managers, and the public at large support the system, and it has often resulted in workers who are more engaged and have a real voice in their workplaces. Management and labor have cooperated, which in turn has led to higher productivity, fewer strikes, better pay, and safer working conditions for employees, which is a classic win-win for both sides. Pay and productivity in the United States. Some managers, politicians, and even members of the general public believe unions are a big part of the reason that U.S. companies have difficulty competing in the global economy. The conservative think tank Heritage Foundation conducted a study that concluded unions may be responsible, in part, for a slower work process and reduced productivity. 44. However, multiple other studies indicate that U.S. productivity is up. 45. Productivity in the United States increased 74% in the period 1973 to 2016, according to the OECD. In global productivity rankings, most studies indicate the United States ranks quite high, among the top 5 or 6 countries in the world, and number 2 on the list compiled by the OECD, Table 6.3. Productivity in 2015, by country, sample of 8 industrialized nations. Country productivity, output hours worked. Australia 102.20, Canada 109.45, Germany 105.90, Japan 103.90, Mexico 105.10, South Korea 97.60, United Kingdom 100.80, United States 108.87. Table 6.3. This table compares 2015 productivity among several industrialized nations. U.S. productivity ranks high on the list. 46. During the same period as the productivity gains discussed in the preceding paragraph, 1973 to 2016, wages for U.S. workers increased only 12%. In other words, productivity has grown 6 times more than pay. Taken together, these facts mean that American workers, union members or not, should not shoulder the blame for competitive challenges faced by U.S. companies. Instead, they are a relative bargain for most companies. Figure 6.12 compares productivity and pay and demonstrates the growing disparity between the two, based on data collected by the Economic Policy Institute. The graph is titled Employee Productivity and Compensation, 1950 to 2010. The y-axis shows percentages from 0 to 250%, increasing by 25% increments. The x-axis shows years from 1950 to 2010, increasing by 10-year increments. The trend line for productivity starts at 0% and increases steadily overall to almost 250%. There are slight decreases around 1974 and 1982, and larger increases around 1983 and 2005. The trend line for hourly compensation starts at 0% and steadily increases in line with productivity until about 1974 at about 100%. It then fluctuates and decreases to about 80% around 1990 to 1995. Then it begins to increase again until reaching about 120%. Figure 6. 12 in the last 4 decades. Wages in the United States have not kept up with productivity. According to the Economic Policy Institute, from 1948 to 1973, hourly compensation rose 91%, which closely follows productivity gains of 97%. However, from 1973 to 2013, hourly compensation rose only 9%, whereas productivity rose 74% in the same period. Attribution. Copyright Rice University, OpenStax, under CC by 40 license. Is management compensation fair? We gain yet another perspective on labor by looking at management compensation relative to that of employees. Between 1978 and 2014, inflation-adjusted CEO pay increased by almost 1,000% in the United States, while worker pay rose 11%. 47. A popular way to compare the fairness of a company's compensation system with that in other countries is the widely reported pay ratio, which measures how many times greater CEO pay is than the wages for the average employee. The average multiplier effect in the United States is in the range of 300. This means that CEO pay is, on average, 300 times as high as the pay of the average worker in the same company. In the United Kingdom, the multiplier is 22. In France, it is 15. And in Germany, it is 12. 48. The 1965 U.S. ratio was only 20-1, which raises the question, why and how did CEO pay rise so dramatically high in the United States compared with the rest of the world? Are CEOs in the United States that much better than CEOs in Germany or Japan? Do American companies perform that much better? Is this ratio fair to investors and employees? A large part of executive compensation is in the form of stock options, which frequently are included in the calculation of an executive's salary and benefits, rather than direct salary. However, this, in turn, raises the question of whether all or a portion of the general workforce should also share in some form of stock options. Linked to learning. Some corporate boards claim executive pay is performance-based. Others claim it is a retention strategy to prevent CEOs from going to another company for more money. This video shows former CEO Stephen Clifford discussing CEO pay and claiming that U.S. executives often dramatically, and in many cases unjustifiably, boost their own pay to astronomical levels, leaving shareholders and workers wondering why. He also discusses how it can be stopped. Everyone wants to be paid fairly for their work. Whether CEO or administrative assistant, engineer or assembly line worker, we naturally look out for our own best interest. Thus, management compensation is a topic that often causes resentment among the rank and file, especially when organized workers go on strike. From the employee viewpoint, the question is why management often wants to hold the line when it comes to everyone's wages but their own. Cases from the real world. Verizon strike. More than 40,000 Verizon workers went on strike in 2016, figure 613. The strike was eventually settled, with workers getting a raise, but bitter feelings and distrust remained on both sides. Workers thought management salaries were too high. Management thought workers were seeking excessive raises. To continue basic phone services for its customers during the strike, Verizon called on thousands of non-union employees to perform the strikers' work. Non-union staff had to cross picket lines formed by fellow employees to go to work each day during the strike. Enmity toward these picket line crossers was exceptionally high among some union members. This image shows a group of people dressed in matching red shirts in an area enclosed with signs that say, CWA on strike for good jobs at Verizon Wireless, and CWA and IBEW on strike, fighting corporate greed at Verizon. Figure 613 union workers from the Communications Workers of America and the International Brotherhood of Electrical Workers are shown walking a Verizon picket line. They are protesting Verizon's decision to not provide pay raises. Credit: Modification of Verizon on strike by Marco Verch/Flickr, CC by 20. Critical thinking. How does management reintroduce civility to the workplace to keep peace between different factions? How could Verizon please union workers after the strike without firing the picket line crossers, some of whom were Verizon union employees who consciously chose to cross the picket line? Learning objectives. By the end of this section, you will be able to explain what constitutes a reasonable right to privacy on the job, identify management's responsibilities when monitoring employee behavior at work. Employers are justifiably concerned about threats to and in the workplace, such as theft of property, breaches of data security, identity theft, viewing of pornography, inappropriate and/or offensive behavior, violence, drug use, and others. They seek to minimize these risks, and that often requires monitoring employees at work. Employers might also be concerned about the productivity loss resulting from employees using office technology for personal matters while on the job. At the same time, however, organizations must balance the valid business interests of the company with employees' reasonable expectations of privacy. Magnifying ethical and legal questions in the area of privacy is the availability of new technology that lets employers track all employee internet, email, social media, and telephone use. What kind and extent of monitoring do you believe should be allowed? What basic rights to privacy ought a person have at work? Does your view align more closely with the employer's or the employee's legal and ethical aspects of electronic monitoring? Monitored workstations, cameras, microphones, and other electronic monitoring devices permit employers to oversee virtually every aspect of employees' at work behavior. Figure 6.14. Technology also allows employers to monitor every aspect of computer use by employees, such as downloads of software and documents, internet use, images displayed, time a computer has been idle, number of keystrokes per hour, words typed, and the content of emails. According to a survey by the American Management Association, 48% of employers used a form of video monitoring in the workplace, and 67% monitored employee internet use. In 30% of the organizations responding to the survey, this electronic monitoring had ultimately led to an employee's termination. 49. Left shows a surveillance camera. Right shows an email sharing insider information about a stock purchase. Figure 6.14. Electronic monitoring often captures data from cameras, computers, and listening devices. This information can then be used against employees accused of violating company policy, raising privacy concerns. Credit left. Modification of surveillance video cameras Gdynia by Paul Z. D. Zayerski/Wikimedia Commons, CC2. 5. Credit right. Credit. Modification of keylogger screen capture example by Flippy Flink/Wikimedia Commons, public domain. The laws and regulations governing electronic monitoring are somewhat indirect and inconsistent. Very few specific federal statutes directly regulate private employers when it comes to broad workplace privacy issues. However, monitoring is subject to various state rules under both statutory and common law, and sometimes federal and state constitutional provisions as well. The two primary areas of the law related to workplace monitoring are a federal statute called the Electronic Communications Privacy Act of 1986, ECPA, and various state common law protections against invasion of privacy. 50. Although the ECPA may appear to prohibit an employer from monitoring its employees' oral, wire, and electronic communications, it contains two big exceptions that weaken its protection of employees' rights. One is the business purpose exception. This allows employers, on the basis of legitimate business purposes, to monitor electronic and oral communications, and employers generally assert a legitimate business purpose to be present. The other widely used exception is the consent exception, which allows employers to monitor employee communications provided employees have given their consent. According to the Society for Human Resource Management, the ECPA definition of electronic communication applies to the electronic transmission of communications, but not to their electronic storage. Therefore, courts have distinguished between monitoring electronic communications such as email during transmission and viewing emails in storage. Viewing emails during transmission is broadly allowed, whereas viewing stored email is considered similar to searching an employee's private papers, and thus is not routinely allowed under the ECPA unless certain circumstances apply. E.g., the emails are stored in the employer's computer systems. 51. In general, it is legal for a company to monitor the use of its own property, including but not limited to computers, laptops, and cell phones. According to the ECPA, an employer-provided computer system is the property of the employer, and when the employer provides employees with a laptop they can take home, it likely violates no laws when it monitors everything employees do with that computer, whether business-related or personal. The same is true of an employer-provided cell phone or tablet, and always true when an employer gives employees notice of a written policy regarding electronic monitoring of equipment supplied by the company. Generally, the same is not true of equipment owned by the employee, such as a personal cell phone. However, an important distinction is based on the issue of consent. The consent provision in the ECPA is not limited to business communications only. Therefore, a company might be able to assert the right to monitor personal electronic communications if it can show employee consent, although this is very likely to worry employees, as discussed in the next section. Another consideration is whose email server is being used. The ECPA and some state laws generally make it illegal for employers to intercept private email by using an employee's personal log on user ID password information. Although the ECPA and National Labor Relations Act are both federal laws, individual states are free to pass laws that impose greater limitations, and several states have done so. Some require employers to provide employees advance written notice that specifies the types or methods of monitoring to which they will be subjected. Examples of state laws creating some degree of protection for workers include laws in California and Pennsylvania that require consent of both parties before any conversation can be monitored or recorded. Employees can bring common law privacy claims to challenge employer monitoring. Common laws are those based on prior court decisions rather than on legislatively enacted statutes. To prevail on a common law claim of invasion of privacy, which is a tort, the employee must demonstrate a right to privacy with respect to the information being monitored. Several state constitutions, such as those in Louisiana, Florida, South Carolina, and California, expressly provide citizens a right to privacy, which may protect employees with respect to monitoring of their personal electronic information and personal communication in the workplace. One additional regulatory consideration applicable to electronic monitoring is whether the company's workforce is unionized. The National Labor Relations Board, the federal labor law agency, has ruled that the video surveillance of any portion of the workplace is a condition of employment subject to collective bargaining, and must be agreed to by the union before implementation, so employees have notice. If a workplace is not unionized, the majority are not, then this federal regulation requiring notice does not apply, and as stated previously in this chapter, if there is any protection at all, it would have to be given by state regulation, which is rare in the private non-governmental sector. What constitutes a reasonable monitoring policy? Many employees generally are not be familiar with the specific details of the law. They may feel offended by monitoring, especially of their own equipment. Companies must also consider the effect on workplace morale if everyone feels spied upon, and the risk that some high-performing employees may decide to look elsewhere for career opportunities. Employers should develop a clear, specific, and reasonable monitoring policy. The policy should limit monitoring to that which is directly work-related. For example, if a company is concerned about productivity and the goal of monitoring is to keep tabs on employee performance, then neither keystroke logging nor screenshot recording is necessary. Software designed to show idle time or personal internet use would be more helpful in identifying wasted time, which is the ultimate goal. Employers should always remember their business goals when monitoring employees. It is not only a matter of treating employees ethically. It also makes good business sense to ensure that monitoring pertains only to business matters and does not unnecessarily intrude into the privacy of employees. Perhaps most importantly, in the interest of fairness, the monitoring policy must be communicated to the employees. When, if ever, is it acceptable to monitor without notice to the employee and without his or her knowledge? Link to learning. This notice by the state of Connecticut mandates that all employers inform employees of the kinds of electronic monitoring, of their activities and communications that may be undertaken at work, and the responsibilities of an employer. Read the notice and decide whether you think it is a reasonable policy. Would it make sense to the average worker? Do you think it is unfair to either party? The Connecticut policy in the preceding link to learning applies to all employers, i.e., in state and in private sector workplaces. However, many states have policies that apply only to employees who work for the government. State employees hold a special status that conveys certain state constitutional rights with regard to due process, reasonable searches, and related legal doctrines. The same is true for federal government employees and the U.S. Constitution, which means the government has a duty of fairness in employee surveillance. It does not mean, however, that the government cannot monitor its employees at all, as demonstrated by an incident involving a California police officer. In a unanimous decision in Ontario v. Kwan, 52, the U.S. Supreme Court in 2010 ruled in favor of a police chief in Ontario, California, who read nearly 500 text messages sent by one of his sergeants on a police-issued pager. Many of the text messages were personal, and some were sexually explicit. Only a few dozen were work-related. The justices agreed that constitutional limits on unreasonable searches by public employers under the Fourth Amendment were minimal given a work-related purpose. This decision creates precedent for more than 25 million employees of federal, state, and local governments, and limits their expectation of privacy when using employer-issued tools. Because the search by the police chief was motivated by a legitimate work-related purpose, and because it was not excessive in scope, the search was reasonable, said Justice Anthony M. Kennedy. In the private sector, where employees are not working for the government and the constitutional prohibition on unreasonable searches and seizures has very little applicability. If any, employers have even more latitude in terms of employee monitoring than in a government setting. The Ontario v. Kwan case in all likelihood would never even make it to court if the employer were a private sector company, because the issue of whether getting the text message was a reasonable search and seizure under the Fourth Amendment does not apply in a non-government employment setting. The Constitution acts to limit government intrusions, but does not generally restrict private companies in this type of situation. However, ethical considerations may encourage private sector employers to treat their workers respectfully, even if not required by law. What would you do? Security versus privacy. You manage a large, high-end jewelry store with an international clientele. Your workforce of 150 is demographically diverse, and your employees are trustworthy as a rule. However, you have experienced some unexplained loss of inventory and suspect a couple of employees are stealing valuable pieces, removing them from backroom storage safes, and handing them off to another person somewhere in the store who leaves with them, or to a third person pretending to be a customer. To prevent this, your assistant managers are urging you to place discrete cameras in the restrooms and break rooms, where these exchanges are likely occurring. Some managers might be concerned about using cameras at all due to privacy issues. Others might want to use them without notifying employees or putting up signs because they do not want to tip off the suspects or deal with the negative reaction of the workforce, although that brings up invasion of privacy issues. You are weighing the pros of catching the thieves against the possible loss of other employees' trust. Critical thinking. What issues must you confront as you decide whether you will take the recommendation of your assistant managers? What ultimately will you do? Explain your decision. Drug testing in the workplace. Key issues that arise about a drug testing or monitoring program. Begin with whether an employer wants or needs to do it. Is it required by law for a particular job under state or local regulations? Is it for pre-employment clearance? Does the employer need employees' permission? Does a failed test require mandatory termination? With the exception of employers in industries regulated by the federal government, such as airlines, trucking companies, rail lines, and national security-related firms, federal law is not controlling on the issue of drug testing in the workplace. It is largely a state issue. At the federal level, the Department of Transportation does mandate drug testing for workers such as airline crews and railway conductors, and has a specific procedure that must be followed. However, for the most part, drug testing is not mandatory and depends on whether the employer wants to do it. Multiple states do regulate drug testing, but to varying degrees, and there is no common standard to be followed. Testing of job applicants is the most common form of drug testing. State laws typically allow it, but the employer must follow state rules, if they exist, about providing notice and following standard procedures intended to prevent inaccurate samples. Testing current employees is much less common, primarily due to cost. However, companies that do use drug testing include some in the pharmaceutical and financial services industries. Some states put legal constraints on drug testing of private sector employees. For example, in a few states, the job must include the possibility of property damage or injury to others, or the employer must believe the employee is using drugs. Challenging a drug test is difficult because tests are considered highly accurate. An applicant or employee can refuse to take the test, but that often means not being hired or losing the job, assuming the worker is an employee at will. The concept of employment at will affirms that either the employee or the employer may dissolve an employment arrangement at will, i.e., without cause, and at any time unless an employment contract is in effect that stipulates differently. Most workers are considered employees at will because neither the employer nor employee is obligated to the other. The worker can quit or be fired at any time for any reason because there is no contractual obligation. In some states, the employee risks not only job loss, but also the denial of unemployment benefits if fired for refusing to take a drug test. Thus, the key concept that makes drug testing possible is employment at will, which covers approximately 85% of the employees in the private sector. Unionized workers and top executives have contracts and thus are not at will, nor are government employees who have due process rights. The only legal limitation is that, in some states, the drug testing procedure must be fair, accurate, and designed to minimize errors and false positive results. The drug testing process, however, raises some difficult privacy issues. Employers want and are allowed to protect against specimen tampering by taking such steps as requiring subjects to wear a hospital gown. Some employers use test monitors who check the temperature of the urine and/or listen as a urine sample is collected. According to the Cornell University Law School Legal Information Institute, some state courts, e.g., Georgia, Louisiana, Hawaii, have found it an unreasonable invasion of privacy for the monitor to watch an employee in the restroom. However, in other states, e.g., Texas, Nevada, this is allowed. 53. Case examples abound of challenges based on privacy concerns. In an article in the Harvard Journal of Law and Technology, University of Houston Law School professor Mark Rothstein, who is director of the Health Law and Policy Institute, summarized examples of legal challenges. 54. In one case, the court ruled that an employer engaged in unlawful retaliation, as defined by the Mine Safety and Health Act. The employer dismissed 2 employees who were required to urinate in the presence of others, but found themselves unable to do so. In a different case, $125,000 in tort damages was awarded to a worker for invasion of privacy and negligent infliction of emotional distress, as a consequence of his being forced to submit a urine sample as he was being directly observed.